He told me he mailed in something.
All right, everybody, welcome to the Creative Finance Collective. This is our opportunity to get together and talk about all things creative finance and real estate. If you're just now joining us, which you would be just now joining us since we're just now starting, we're here to take questions. So if you have questions, make sure to post them in the chat. We'd love to answer them. And really, we're on here for an hour, but we'll be on here at least as long as we have questions. So if we stop getting them, we're going to move on. So make sure to post those questions in the chat. We have a few people with us. We got Scott Horn over there in Texas, and Sean St. Clair, and Drew Jenkins over there in Georgia. How's everybody doing?
So it's 10,726.
Yeah, sounds
I
like
think it was on
somebody.
Scott's side, whatever that was.
Yeah, that was me, guys.
Yeah. So, what's Drew? What are your plans for Thanksgiving?
We are going to see family over in Huntsville, and then we're trying to decide what to do. Having a little bit of fun. We've rented an RV, so Amber and I are going to pick it up in the morning, throw all our stuff in it, and then, drive across the state. That way, we're not having to, take up someone's bedroom or something in, one of the family's houses or something like that. And then we can make a fun little road trip for the long weekend.
Wow, that's
So
cool.
it should be fun.
That's cool.
You guys?
Not renting an RV. Used to own that.
So I plan to eat, take a nap, take a nap. Does that count?
I was.
Are
gonna
the
say-
Cowboys on Thanksgiving, Scott?
Oh, I'm sure they are. Maybe they'll
They're
get
not-
lucky again, like they did the other night. But who cares? Is where we are today. Kind of things, kind of.
when you
Oh
were
my gosh!
when you were explaining eat, take a nap, I was like, we're not talking about Monday through Friday, Scott. We're talking about Thanksgiving.
No, I know. No, I have got so many things to do. I mean, granted, all my family is local, which is great, so it makes life easy. My niece and my nephew-in-law live right next door to me, so everybody's going to congregate there for the day. Actually, it starts Wednesday night, then Thursday, probably Friday night. So we get that fun thing to do: pick up more leaves, put out Christmas lights. All the fun things you got to do.
Yeah.
I got to replace the deck on my shed. So if y'all are bored, want to come over and do that, come help.
There you go.
I'm always open to help.
Yeah. Well, we're waiting. We went live a little bit ago. We're waiting for more people to join. If you're just now joining us, we're taking questions on creative finance or real estate issues. So make sure to post them in the chat. This is a holiday week, so we've got maybe other things to do. So we'll be on here as long as we've got questions. While we wait to see if we get any other questions. Scott, Drew was on our show earlier today, and we spent a lot of time talking about FinCEN and the new reporting requirements for agents and closing agents. Have you been tracking that at all, Scott?
No. Update, please.
Oh yeah. Well,
Yeah.
why don't Drew? Why don't you just give them a little primer on what's coming, unless we're saved by the DOGE, the Department of Government Efficiency.
Hey, Scott, are any of the areas you operate in, are they subject to any of those geographic targeting orders?
I don't know the geographic targeting orders. I'm so lowly, forgive me.
The Fed. No, the feds are worried about money laundering. For years, they have picked specific jurisdictions that they have required title companies and settlement agents to report, basically a short form of a SAR, right? Under the Bank Secrecy Act. And they've decided that it was such a success at rooting out potential illicit transactions that they're going nationwide with it. So a new requirement for us will be we have 30 days after any closing to file essentially a streamlined suspicious activity report for any residential real estate transaction in which the transferee is an entity, including trusts and general partnerships, and that was not financed through an AML compliant institution. So that's cash and or most hard money lenders, I would say.
So that would include a seller finance transaction.
Yeah. So we just got
Absolutely, yes.
so we just
Yes, absolutely.
yeah. Hold on. We just got that question on YouTube. Will the FinCEN reporting requirements impact closing a subject to sale? Why don't we talk about it? So we just got the answer yes. Break down why. Whoever wants to do that.
Drew, you're the most on top of that. So
I mean, it's a cash sale. The reasoning is very clear. You did not have to disclose your information to an AML compliant lender who has a separate obligation under the Bank Secrecy Act to report you. That's why you are going to be subject to it under the new rules, is because from our perspective, it's a cash deal, right? Because you're taking subject to, and even if you were not taking subject to, you did not go through the beneficial ownership disclosures that you would have had you had been the initial borrower under the loan. So you're absolutely is going to have that report filed on you.
so
You know, I'm going to back up just a moment. Did we not talk about this on a previous program?
yeah, I brought it up briefly.
We
Yeah,
did.
we talked about it.
I think the solution we all had about this is we hope it goes away. But as of now, it's here. It's kind of like the, all these damn acronyms. What's the business disclosure, beneficial ownership?
CTA.
The CTA.
Yeah, CTA crap. You know, just one more thing the government wants to do for you, you know. And yes, please pray that Doge works and they get rid of all the regulatory junk that's not needed out there. But it's just like, okay, it's just more time and it's more money. It's going to trickle down to the client to cover the things you got to do.
So I'm curious, Drew, so FinCEN is an agency of the federal government, right? HUD is an agency of the federal government. A common strategy for subject to transactions is to create a land trust, put the property into the land trust. As we talked about, trusts aren't exempt except for certain circumstances. If I go and report all the beneficial ownership information on this trust to FinCEN, does HUD have the ability to go to FinCEN and be like, hey, we're all feds here. How about some of that data?
That's a great question. They haven't laid out. So what I do know is this: several of the comments were, why don't you just use the BOI, right? Like, why make us create a separate index? And other people said, well, you're already reporting most of this information anyway to the IRS, at least with respect to the sellers or the transferors, right? Your 1099s and your FERPTAs and all that. Why don't you just use the IRS? And their reasoning is, all of these different agencies have different disclosure requirements, and we're not certain that the IRS data is extremely private, even though it's the craziest thing. We are literally sending the exact same information to FinCEN that we're also transmitting to the IRS. So the whole argument is, tax data is heavily protected. I'm literally telling you the same thing I'm telling them, right? As with respect to your transferors. And they're like, well, the BOI, certain entities may not have access to that. I think they're talking about sharing it with local law enforcement. Like, the whole concept of this particular reporting regime is making sure that local law enforcement have the ability to suss out typologies. Again, they're not even saying that it's money laundering. It's just transactions that are arranged in a way that raise suspicion. And of course, we don't know that, but they apparently do. So yeah, the reasoning is it's going to be a separate database that's going to, I assume, be easier for law enforcement to access.
I got a question that just came to mind. Talking about cash type transactions, right? What about foreclosure auctions?
We had this discussion.
Which is always a cash transaction, right?
Yep.
Yeah.
I mean, always cash transaction. So does that
Yes.
mean that the trustees now have to
Yes.
report the same thing too? 'Cause I'll tell you what, here in Dallas, Fort Worth, and a couple of the other major cities in Texas, you go to these auctions, and what blows you away is how much people pay for property. And it's been that way for many, many years now. Not just 80 cents on the dollar a night. We're talking 110 cents or more. So we know what the value of these things should be and what to offer for them. And you watch the pricing structure, you go, holy bejeebers, who is paying that kind of money? And it's got to be, we believe it's, coming in from Asia where they're just trying to park money. It's cartel money here in Texas doing it. And grant you, I haven't been down to the McAllen area and Brownsville, those areas in far South Texas to go to one of their auctions. I don't want to do. That's where heads might roll as far as I know. But we have been seeing this for so long here. You just scratch your head going, who in their right mind would actually pay that kind of money? And I get that these hedge funds paid some stupid money previously to buy houses. That was 8-10 years ago. That's filtered out of the system now. But you watch that, and I understand why the government would want to know something like that. Because we suspect there's always a lot of money laundering going on in those scenarios. But that's a whole bunch of recording that these trustees have to do now, if that's the case also.
Yep.
So
And that is
if
the
I can
case
just
if it's
read
non-judicial.
the paragraph that's from the comments. The final rule also does not adopt the suggestion to exclude foreclosure sales. Although Finson notes that foreclosure court proceedings wherein a lender obtains a judgment to foreclose on property would be excluded under the exception for transfers required by a court of the United States. Outside of such court-supervised foreclosure proceedings, Finson does not agree that potential reporting persons involved in sales of foreclosed property should be treated differently from other transfers, as such sales where the property is sold to a third party do not necessarily present a lower risk for money laundering.
Oh, I hear that kind of an explanation. I'm going, what's the difference? There is none. A court-ordered sale, you still go down to the auction. It's auctioned off in traditional fashions. Same
Right.
thing. No difference.
Yeah. The sheriff is not figuring out who's purchasing or not purchasing. The sale's the same.
No, and whether
Amazing.
here in Texas, the sheriffs do our they do our tax lien foreclosures, judgment lien foreclosures, executions, those things. The attorneys typically do all of the other foreclosures. Even if it's a judicial foreclosure, you just get an order and you go down and foreclose, right? And it's the same process. Why would that be exempted? That's your wonderful government at work again, not thinking through things.
No, they've exempted anything in which a court supervises the transaction. So they've exempted bankruptcy sales. They've exempted, court-ordered sales. Yeah.
Yeah, it's about 0.1% here in Texas, being a non-judicial state.
Yeah. Probably the same in Arizona.
Yeah.
I'm sure there's going to be a lot more of them.
Yeah, that's where this is going. So
the reporting can't be that hard to do. It's just a time thing to go online, fill the form out, and submit it, right?
Yeah,
like Andy brought up. Yeah, the foreclosures have a special wrinkle when it comes to filling out the form. Just to let you know, the form cannot be filled. It must completely leave blanks, and I'll let Andy explain what's wrong with the trustee sales.
Well, I think what we were discussing earlier today was the problem of, I guess if there was some conventional loan and there's loan servicers and the borrower's name and social security information is all there, then it's all there. But if it's somebody who, did a seller carry on their own, or maybe they didn't use a title company, maybe they didn't use a servicer, and they just kind of papered it on their own. Maybe they did even a good job papering it on their own, and we're left to foreclose. What happens if you don't have all of the borrower's information. You just have the names. You don't have the social security number, all the stuff that's required. Then I think basically under this, you're really forced to go judicially foreclose at that point.
Well,
I don't
we
know
go.
how you can report it.
So I'm going to do a follow up here real quick, then I'll bring that in too. But you said it's to an entity.
Well,
For the
entity is
foreclosure,
defined
for
very,
the,
very broadly.
Okay, so trust, limited partnership,
Yes.
LLC, corporation, but to an individual, you don't have to do it.
Correct.
Correct.
Okay, got it.
That is correct.
So just FYI, when we go down to the foreclosure auctions, we take our recorder's receipt with us, our sale receipt, and we get all of the borrower's information, right down the line, name, address, whatever it might be. And it sounds like you've got to include the EIN on there as well. And I guess if you don't get something, you don't record the trustee's deed until you get what you need. You just have to hold it back. It just adds another layer of complexity to the process that you have to think about as you're handling those things.
The issue becomes you have to have the property owners, the original property owner / borrower's information.
The original.
Yeah, you have to have this. Yes, you have to have the seller. So in a regular transaction, you have to have all the seller's information and report that as well. And so,
well, is it when you say seller, Sean? Is that I'm going to throw several examples out just to confuse the heck out of us. Okay, let's just get a menagerie going on here a little bit. So I get that if you've got a mortgage company who created a loan, that loan could have been sold to mortgage company 2 or 3. Mortgage company 3 is handling the foreclosure. Are you implying you have to go back to who the original lender was? And that's okay. Just the foreclosing entity, you need their info. Then you need the borrower info at closing, right? Got it. Okay. So let's take and go this one step further. Let's assume Mr. Investor out there has bought a home subject to the existing debt. He does a wraparound loan to a borrower. So I'm probably reiterating what you guys have already talked about earlier. So if I have, sorry, you'll get more practice. So investor buys sub 2, does a wraparound, and now he's foreclosing on the wraparound mortgage. Okay. Well, obviously we know who for that foreclosure purposes of the lender, we'll know who the buyer is at the auction. If it's a third party, got it, or themselves. But do they need to recite the original mortgage company info on there? Okay.
no, but the borrower who was the end buyer that purchased it,
Yeah, you got to have all their info.
you have to have all their info. So if you didn't get their info up front and they don't cooperate at the time of the sale, you may not be able to non-judicially foreclose.
Okay, so the person that is getting foreclosed upon,
Yes,
got to have all their info,
correct,
as well as the buyer at the auction.
correct.
And not just the buyer's info. It's like opening a bank account. You need to know who owns it and who manages it and get their tax identification numbers and their addresses.
When you say manage, you mean like a loan servicer possibly?
No, I mean like a manager for an LLC, right? So if all four of us, had an LLC together and, we elected Scott, you as the manager, we're going to need four SSNs, 4 addresses, one for each of us as owners, and then one for you as the manager. It's the CTA's regime being brought down to real estate transactions.
Holy cow. So you need all owners of the LLC or the corporation, all the shareholders?
If it's not publicly
That's what it
traded.
says.
Hey, and Scott, guess who's exempted out of this thing?
Yeah, not us.
No.
Wall Street.
Well, the publicly traded companies, right? It's the publicly traded ones, right?
Yes. Yeah.
Yes.
That's just like CTA.
And it's the
same
banks
way.
themselves. Yeah, and it's the banks themselves. So if a bank did do a non-judicial foreclosure, so long as they purchased at their auction, they're also exempt. And then, they can sell it and it would be it would be their 10 that they would use when they sold it to their ultimate buyer. So REOs are going to become a lot more practical, I guess.
So you've got to have the social security numbers of all the member managers of an LLC or the directors of a corporation.
Let's see, adopts
it's
reasonable
not-
reliance standard.
If they own 25% or more interest.
Yeah.
Yes, it's
And you
the exact.
You just make
Yeah.
that an automatic.
It's the Bank Secrecy Act, the legal entity, beneficial owners of that transferee entity or transferee trust. Yeah.
You have to bring this up before Thanksgiving holiday. You could have done this next week.
Yeah. Well, the other thing we were talking about too is we kind of talked about this at the end of the show, but what this also loops in are those kind of those small mom and pop investors that own like, an extra house or two that are going to rent it out, and they just want to deed that home into an LLC for asset protection purposes. You've seen those. We've all done a transaction for those kind of persons, just small time stuff that falls in under these reporting requirements as well. And remind, just because I know Scott will like to hear it, Drew, I don't remember them all, so I'm going to lean on you, but the penalties that you can face.
Let me pull that up real quick. Yeah, so there's actually multiple sets of penalties. Consistent with whatever, it is unnecessary to list potential penalties in the regulatory because they're already set forth by statute. Because, Scott, I didn't know this. Did you realize that we are defined as financial institutions under the Bank Secrecy Act? Whenever that passed so many decades ago. Regulations for us. That's how they have the power to do this, is we're actually written into the statute as financial institutions.
That's a title
settlement
company or a law
agent
firm,
and
or-
title companies. Settlement agent, not law firm, but settlement agents. They catch us a separate way. But yeah, so we are apparently in the statute from way back when. They just declined to regulate us, and now they are regulating us. So here's the penalties. A final rule, a civil penalty as of the publication of not more than $1,394 for each violation, and an additional civil monetary penalty of up to $108,000 for a pattern of negligent activity. Willful violations could result in a term of imprisonment of not more than 5 years, or a criminal fine of not more than $250,000, or both. In addition, such violations could also result in another civil penalty, not greater than the amount involved in the transaction, not to exceed $278,937, or $69,733. This penalty structure generally applies to any violation of a BSA requirement. We are now under the same penalty regime as banks. So better file that form. And remember, it has to be fully filled out. You cannot submit partial forms.
Can I just get my mobile golf bag that follows you around the golf course and go down to the beach and fill it full of beer and sell beer on the beach? Just one more damn thing we got to worry about besides keeping up. See, you guys in other states, you don't have all the compliance issues like we have here in Texas on the creative finance deals. That they just keep heaping them on top of us. You got to stay on top of all this junk, and none of the investors know that they're out there, and you got to talk to them, ad infinitum. And they just one more thing.
Right. Now, to make it even worse, and this is something Sean brought up, is this applies not only to entities, but it also applies to like general partnerships. So if you and a buddy decide that y'all are going to like have a partnership, congratulations, you're subject to this as well.
Yeah, that means if two individuals buy a property together, there's going to be an assumed partnership.
Yes.
Yeah. Awesome. What other good news do you have? That there's no Santa Claus also?
Yeah. What on earth are we supposed to be thankful for? It's Thanksgiving. Come on, Drew.
Hey,
Wow.
y'all are the ones that booked this, not me.
I brought it up. You're right. I brought it up. I wanted to
Well,
terrorize the listeners.
But
maybe we can
I
be
think you're trying
thankful
to hide
for
it is what you're
Doge.
doing.
I think this is just fair game to our audience, guys, that, when I get the title world is the title world. So they add that to it. Of course, our departments of insurance regulate all this stuff that we do along the way. You got to follow that and this and that. I get it. So in a sense, from a title world, I understand. And guys, when you have people come in, I've had people come in my office. One guy came in one day with a suitcase, walks in, he's closing this deal. And the dude brings $190,000 in cash. And so first thing is where in the go lock the door. The next thing is where the heck did this come from? And then the next part is yeah, we can't accept it. But you see those kind of things, and although in reality that was innocent, the first thing in your mind is well, how many drugs did you sell to get it, or where did it come from? And I have gotten a lot of calls from the Hispanic community, from Hispanic, various Hispanic marketing reps who deal with a lot of people in Mexico who want to bring money over, but they don't want to bring it through traditional banking routes. They just want to bring cash and go, here, can you help me invest it? And when you hear all that, of course, your radar goes up and it's like, yeah, no, can't do that. And even if you could go get money orders and cashier checks, it's like you need to deposit it through traditional banking mechanisms, and then we'll talk about it, so long as the money comes from a legitimate U.S. bank. So I understand what they're trying to do, but for the poor settlement guy out there, like in our law firm and in our other company, OFN Nationalists, there in Scottsdale, holy cow, that's another 80 a month right now of deals you've got to do. Because, again, 99% of all of our transactions, whether it's subject to or wraparound, whatever it might be, are two entities. So it's just going to be an automatic thing, add another, amount to the bottom line, and is what it is.
Well, we have, correct me if I'm wrong, Drew, but we have until December 2025 to get ready for it. That is if it's not set aside with the new administration, I suppose.
So wait, I know we talked about this last time, the 1225 date. You just felt like you needed to bring this up again, even though it's a year off?
Well, we had a whole...
We finally have the final rule, right? They finally closed the comment period and they published the final rule. So now we know what it's going to look like.
Well, this is that wonderful
takes effect.
Biden administration just wanting to put more crap on everybody. They're making life more difficult for us, for the new administration, and everything else ongoing. I'll get off my soapbox.
Sean, you're on mute. Maybe he wants to.
We should all
It might
post
be a
on
good thing
those.
for him to be on mute.
Probably, because we should all post on that survey that Doge is going to do as far as the agencies we want to see, ousted, and put like FinCEN or on there to at least try to get some effort to see if they'll do something about it.
Yeah, well, there was the whole, Drew, we were talking about this earlier, but even by their estimates, this wasn't the money that they thought that they would stand to gain by information was less than what it was going to cost them to do the whole thing, right?
Correct. I pulled it right here. Expected economic benefits, paragraph 4. They anticipate that the anticipated cost of the rule are somewhere between 428.4 million and 690.4 million in the first compliance year, and then somewhere between 4 and 666.3 million or 663.2 million in current dollar value in subsequent years. However, they believe that the intangible benefits are worth over $500,000 a year. So yeah, they're expecting this to cost more than whatever the benefit that they're getting is.
Well, FinCEN is there's legitimate things that they do at FinCEN. I get it. This is just one of those added things that needs to be cut that is cutting more fat out of the system.
Yeah. Yeah.
So yeah.
Yeah. And it's not even in a time when we're cutting, it's not even, it's something they're adding, like a new thing, just to,
Well, if we know what to send out, guys, we can send out a e-blast to about 160,000 investors, at least in the Texas and Arizona marketplace, saying y'all need to write into the Doge website about this one regulation that is absolutely absurd and useless.
Yeah.
As well as the CTA on top of that too.
Yeah. Yeah.
But it might be too late for CTA.
Yeah, we'll see what happens. I think we're going to see a lot happen in the next year. I think we answered this question, but we did have the question posted. Does the reporting requirement apply to a person-to-person transfer, or is it only transfers to entities? I think we answered that, right, Drew? Only to entities.
Well, we have to be careful because it's broader than entities. Again, if you and I buy property together for profit, we're technically a partnership, and that
True.
is subject to, even if we are not a filed entity. So if
Yeah.
it's going from one human to another, or from one human to, or anything, it's going from a person or a person and their spouse, you're fine. But if it's going to any other arrangement that may be for profit or even nonprofit, you're probably going to have to file.
Yeah, good stuff.
Because they didn't exclude nonprofits.
Oh, interesting. Oh, those nonprofits. Well, that we've received all the questions, or we haven't received any other questions. You guys, anything else going on in your communities, creative finance wise, that you have going on? Anything new going on in Texas or Scott, or is it same old when it comes to creative finance?
No, it's just same old. It's just, it's never going to change. Our complaining is never going to change on the investors out in the marketplace. And I hate to, rag on our clients sometimes, but if you're playing the game in Texas, you got to know what the rules and regulations are. I was dealing with a transaction just yesterday where a local investor or out-of-state investor buying a property in Texas is using a New York lender. And it was what was the interest rate end of the day? It was a 5,060. It was a 300% APR interest rate is what it calculated out to be. And it's like, guys, you just need to be aware this is a situation. If you want us to close this, I need an indemnity agreement signed by both the buyer and the lender to hold us harmless because of usury. Now, you guys in Arizona don't have that, but we do here. And I don't know about Georgia, if they've got it or not. No usury?
No, we have a usury law. It's just no one's ever going to hit it.
Well, I've dealt with 8 lawsuits in the last 6 or 8 months on usury here. Now, I haven't dealt with in 25 years probably. And it comes out of this gator lending stuff you hear from Pace Morby stuff. And it's just pointing out to them, it's like, just be aware of what can happen. And they don't care. But, you just want people to take the time, and before you do something and just arbitrarily decide you're going to lend money and charge these fees, nobody ever asks an attorney who is knowledgeable about those items, They just make an assumption and move forward. No, damn the torpedoes.
Yeah.
And I know that will never change. It's just the nature of the beast. And my complaining will never change. It's just same thing, different day.
Yeah.
And it's okay.
Yep.
Got it. Well, one thing I've seen, and I'm surprised I didn't see it sooner, and it just came in today. An old client of mine called, and he's finally borrowing money. So he's bought a bunch of property cash over the years, and some of them, and he's now starting to stick his property in an entity. And I'm like, yeah, I know why. They're going to force you to sign a pledge of your ownership interest, and they're going to file that UCC, that membership interest pledge. It's becoming very, very common to have lenders do that because it's a way that they can get around having to go through a foreclosure and the whole foreclosure timelines. I mean, a UCC foreclosure takes what, 45 days from start to finish? That's a lot quicker than, months of back and forth and then meeting on the courthouse steps, because you can even do these, I think, over Zoom or something like that, right?
Well, so first off, here in Texas, the good part is if we've got a property that is owned by an entity, we can foreclose in as little as 21 days. But if you're in a jurisdiction, unless the document stipulates something otherwise, but usually it says as per the property code then in effect in Texas, and it doesn't have any other specified time frames to cure for a non-owner occupied property. But if you've got a situation out there in a jurisdiction where you have a long foreclosure time frame, you've got 6 months in Arizona, for instance. Now, I don't know what the UCC laws are there, but if you could get them to pledge the interest in that LLC or that corporation, whatever it might be, to you under a UCC, that you can then terminate that and own the entity by by foreclosing on the UCC interest, as you said. That's awesome.
Yeah.
I'd do it too if I was a lender.
Well,
So
what do you
I
do?
already
though?
see in my large commercial transactions because I think it was 2 years ago at this point, New York blessed it, right? It was a big New York case, and everyone agreed. You guys are all sophisticated. This is commercial. You signed it. You're stuck with it. And ever since then, I've been seeing these interest pledges become more and more common. I was wondering when it was finally going to filter all the way down to individual hard money lenders. And I'm pretty sure that's what I just got today on the phone call with my client. He's like, why do I have to put an LLC? And I'm like, I bet I know why.
So do they also take a lien against the property and then they just choose which remedy to pursue then at that point?
I would if I was them.
So what
I
they
kinda
do
like
is
my either or
nowadays
have
we're
my option.
filing, we're filing 3 UCCs. Yeah, we're filing 3 UCCs, right? We've got the UCC fixture filing, we've got the typical UCC one, and then in addition to that, we have the UCC pledge of equity interest in the borrower. And on the hard money side with the lender I'm affiliated with, I think we're on our 3rd or 4th UCC foreclosure, and man, is it fast. And it is, I'm pretty sure, done through Zoom, right? Like we've got, the bigger law firm, based somewhere in the mid-Atlantic, and we just ship it over to them, and, they start whatever those proceedings are, and, we foreclose. It's interesting, but yeah, it's a lot quicker. It's a lot cleaner. The risk you take on is if your, screwball borrower went out and, borrowed additional debt without telling you. But that's why all your loan docs have the
Right.
non-merger clauses, right? You want to make sure that you don't accidentally merge your lien against the property with your ownership in the borrower.
Okay, so you also have a mortgage or deed of trust against that property as well. So you can wipe out any junior liens.
Correct. Yeah, because correct, if needed. There shouldn't be no junior liens, and so long as there's not, you're in a much better position. But even if there is, you
Right.
still have the option, thanks to your non-merger language, to wipe them out.
Makes sense.
All right. Well, guys, it's Thanksgiving week and we don't have any other questions. So why don't we call it? Drew, we've had a long day of FinCEN. We need a vacation from that, but hopefully, hopefully we'll see what the law does next
Started on that
year.
tomorrow.
But
I
yeah,
wish him great dreams about this tonight for bringing it back up all day like this.
I know. Yeah, well, that was me. I brought it up. I will take the blame. Well, good stuff, guys. Enjoy your Thanksgiving, and let's do it again next week.
Happy Thanksgiving, you guys.
Happy Thanksgiving.
Awesome.
Bye, y'all.
All right. Thank you,
All
everyone.
right.